Good evening and welcome to tonight's lecture, Scandal, Malice, and Defamation, and then Soane Sued. I'm Doug Wright, chair of the Soane Foundation's Public Programs Committee, and it's a pleasure to introduce tonight's talk and our distinguished speaker, Professor Timothy Hyde, who has traveled down from Cambridge, to join us this evening. Timothy is an architectural historian and associate professor at the Massachusetts Institute of Technology, where his research explores the intersections of architecture, politics, and law. His work focuses on how architecture both influences and is influenced by legal and political contexts, with particular attention to the relationship between architecture and law in the modern period. He earned his BA from Yale, his MArch from Princeton, his PhD from Harvard. I don't know where his loyalties lie. Timothy is the author of Constitutional Modernism, Architecture and Civil Society in Cuba, 1933 to 1959, and Ugliness and Judgment on Architecture in the Public Eye. His work has been published in numerous journals, including Prospecta and the Journal of Architecture. Currently, he is researching the architectural history of Antarctica, beginning with questions of legal jurisdiction and the built environment. After the lecture, I'll return to moderate a brief Q&A, followed by a reception through this door, where we can continue the conversation over cocktails. Finally, a quick reminder for our next program, which will be on March 24th. You'll receive details via email and on Instagram, so please look for those and join us. Thank you for your continued support of Soane and his remarkable house museum. And now please join me in welcoming Professor Timothy Hyde.
Thank you very much, Doug. And thank you to Suzanne Stevens for the invitation to come speak with you all. Bill, thank you for all the organization. Thank you all for attending to just join in a little bit of conversation about Soane and some gossip and some scandal. On September 30th, 1812, the Morning Post in London published a letter from Ambulator, a pseudonymous reader who wrote to complain of a nuisance. "I presume you have not lately passed," he wrote, "through Lincoln's Inn Fields. Otherwise, I think you would have animadverted on a new-fangled projection now erecting on the Holborn side of that fine square. This ridiculous piece of architecture destroys the uniformity of the row. It is a palpable eyesore." The ridiculous eyesore was the facade of 13 Lincoln's Inn Fields, the home of Sir John Soane. Soane, who was transforming the interiors of his adjacent townhouses, had begun to construct a projecting stone structure, portico, loggia, and balcony that covered the middle facade and rose to a height of 3 stories, a startling contrast to the flat and unadorned brick of the flanking buildings. This idiosyncratic architectural feature disparaged by Ambulator was noticed by local authorities. A second letter, a few days later, advised the editor that, quote, "a multitude of other persons had complained," end quote, of the unusual ornamented facade that disrupted the uniformity of house fronts. And advised also that the district surveyor, judging it to contravene the terms of the Building Act, had, quote, "lodged an information," a complaint or a charge against the unsightly projection, end quote, a charge with the local magistrates. The district surveyor had indeed advised Soane that the projection violated the Building Act, which prohibited enclosed projections that extended beyond the general line of the fronts of houses on a street. When the case was heard before the Bow Street magistrates, the surveyor declared the facade to be a public nuisance, a legal term. Soane's legal counsel replied that the work could in no way be considered a public nuisance because it did not extend beyond the line of Soane's freehold. In the lower right, you see a survey drawn by J.M. Gandy in Soane's office of Lincoln's Inn Field, the green part, with Soane's house in that square at the bottom. Zooming in, you can see what the lawyer was referring to, that the projection did not extend beyond the line of Soane's freehold, the property that he possessed, which actually lay several feet beyond the projection. The projection is marked, hard to see, but marked in pink wash in the drawing, And the line beyond that is the actual legal line of Soane's property. In the photograph, the railing that you see marks the property's freehold. Soane's lawyer then said, quote, "A common nuisance must be that which deprives the public of some advantage or puts the public to some inconvenience. This could not be the case at 13 Lincoln's Inn Fields, where the public was not permitted to enter into Soane's private freehold and thus could never be in proximity to the facade." To further his defense, Soane's counsel then introduced models of other buildings on Lincoln's Inn Fields that included other projections, similar projections that had not been censored. The surveyor tried to explain away these examples but failed, and the magistrates quickly ruled in Soane's favor. So the projecting facade would remain in place. Behind that facade was the domain of Soane's private life. But in London in 1812, Soane was quite a celebrity. And because of that celebrity, the legal case sparked considerable public interest. Even though it received legal approval from the court, the facade of the building could still be, and it surely was, regarded by the public that passed by or the public that read about it as a curiosity of private taste. It was a display of Soane's private persona put forward to the public. It did not physically intrude upon that public and could therefore not be a public nuisance in legal terms. But it did intrude upon the aesthetic attention of the public by its visibility and its idiosyncrasy, or, in the opinion of the ambulator, by being a palpable eyesore. With the Soane Foundation's lecture series theme right now being reception and rejection, in my talk this evening, I want to bring your attention to a few episodes from John Soane's career in which this relationship between public and private, between architecture and reputation, emerged from the genteel settings of Georgian London to become conflict, recrimination, malicious scandal, and even defamation, matters which were settled only by recourse to law. The London in which Sir John Soane lived offered countless venues for production and exchange of opinions. There were streams of correspondence to circulate news and gossips, which made their way into personal diaries, into pamphlets, journals. There were debates, there were lectures staged in drawing rooms and coffee houses, in academies, and of course in Parliament. During the years of Soane's architectural career, talk in all of these forms was a medium of publicity, a word that was used for the very first time in 1791, used to describe, coined, invented, to describe the condition of being rendered into an object of public attention. At that time, dozens of different daily, weekly, and monthly newspapers and journals constituted the London press, the most popular of which had circulations in the thousands. They wielded a powerful influence with political commentary, legal reviews, literary reviews, artistic criticism, financial data, society affairs. Taken all together, these produced a constantly changing rendering of publicity and reputation. Soane himself not only read these publications, we know that he subscribed to the Examiner, the Gentleman's Magazine, and the European Magazine, among others, but he appeared in them as well. His name can be found in the pages of the Morning Post and the Sun, the ambulator's critique, but also the Morning Chronicle, the Examiner, the Literary Gazette, the Times, the True Briton, the Champion, the Guardian, and the Observer. Soane's very attentive and very persistent interest in these media is apparent now in 21 scrapbooks held by the Soane Museum in which he collected newspaper clippings. Favored topics for Soane seem to have included crime reports, parliamentary business, as well as scientific and social curiosities. Here, among other things, you can see snippets, clippings from Soane that address questions of embezzlement, legal issues, chess strategies. The one in the middle right is about how to develop an electric charge from rubbing a cat on the cat's fur. He clipped out other stories of interest, a tale of a young woman who disguised herself in male clothing and worked for several years as a plasterer in the plastering trades. But Soane's favored topics, evidenced by the frequency of its scrapbook appearances in these books, was, of course, Soane himself. For it was not only political members, political figures like the king, parliamentarians that drew the attention of newspapers, but also prominent citizens and prominent figures, now including painters, writers, and yes, architects. New artworks, new books, new architecture, all these were subject to scrutiny, to comment, and to critique. And so, of course, were the architects who created them. On 16th of October, 1796, the Observer published a short poem titled The Modern Goth. Its rhyming couplets sarcastically praised the already well-known John Soane and his new designs for the Bank of England. It paired hyperbolic epithets with belittling comments on Soane's diverse architectural practice. For example, "Glory to thee, great artist, soul of taste, for mending pigsties when a plank is misplaced." The verse also derided the peculiarities or particularities of his developing architectural style. So, for example, the verse here, which was set against the stock office within the Bank of England, makes mock of pilasters scored like loins of pork. So the lines of the pilasters seen in the rendering are seen to be slabs of meat set upon a dinner table. The poem concluded unambiguously, saying, "In silence," to its reader, "in silence build from models of your own. Never, never imitate the works of Soane." Soane's designs for the bank, an institution of enormous civic and political importance, could hardly have avoided prompting some political commentary, particularly given Soane's known disregard for the prevailing conventions of neoclassicism. Soane, concerned to defend his reputation and perhaps also insistent that the right of artistic innovation be championed, chose neither to ignore this satirical attack in the press nor to rebut it with another kind of satirical response. Nearly 3 years passed before Soane could act, but in 1799, Soane took recourse to the law. He entered legal proceedings against one Philip Norris, whom Soane named as the publisher of the Modern Goth. With the encouragement of his legal counsel, Soane submitted to the Court of King's Bench a brief that emphasized the scandalous and malicious, quote unquote, scandalous, malicious nature of the poem, and asserted that the defendant intended to, quote, prejudice, vilify, and disgrace the said John Soane in his profession, and to injure his fame, his credit, and his reputation, end quote. This is the charge sworn out by John Soane. Under prevailing common law principles, civil prosecution for against published statements about an individual that either impaired his position in society by holding him up to public scorn and ridicule, quote unquote, scorn and ridicule, or that had a, quote, tendency to injure him in his profession, his calling, or his trade. Soane's brief, therefore, aimed precisely at these two standards, claiming that the satirical poem was deliberately intended to embarrass him publicly, and that it was intended deliberately to damage his professional reputation. According to Soane's counsel, the very nature of the publication demonstrated this motive. This is Soane's lawyer. Quote, "We may fairly assume that Soane's designs could have been attacked in a more serious way than by the anonymous publication of an abusive poem. All public disquisitions on the subject ought to be fair, manly, and candid criticism. They must not be holding up a man as an object of scorn and ridicule to hunt him down in his profession and to degrade him in society. In the first stated libel, the language is ransacked for terms of scorn and derision. Mr. Soane is held out to the public as a man who has disgraced his country." During the trial, which was reported in daily newspapers such as the Times, the Morning Chronicle, the counsel for the defense argued that although Soane was indeed an architect of great merit, the bank in particular failed to exemplify his talents. The defense lawyer then proceeded to recite the entire poem aloud in court, substantiating each one of its lines, each one of those stinging slights, with a corresponding comment on Soane's design. The bank, the defense counsel concluded, was a public performance that, given its flaws, was a reasonable subject of criticism and even ridicule, provided that the ridicule was done in a fair and manly way. Both parties emphasized the nature of the criticism, whether it was fair or manly or candid, rather than its content, because the motivation behind the defamatory statement could be the evidence of libel, especially in a case where the truth or falsity of the statement itself could not be definitively asserted or proved. The judge, contemplating the case, admitted in his instructions to the jury that, quote, architecture and all the other arts are the subject of fair criticism, end quote, but he advised that the jury must consider, quote, whether that criticism might be done in a poem that was to hold a man up to ridicule all his life long, end quote. The jury did deliberate on these terms and then returned a verdict, not guilty. The poem was judged not to be a libel. The Modern Goth episode was Soane's first of many encounters with scornful publications. Critical letters, pamphlets, and reviews were attendant to his celebrity, and recourse to law became Soane's instinctive response. During these decades, the common law addressing libel in England was undergoing significant evolution. In 1730, a century before almost, a legal commentator had expostulated, quote, must it not appear then a monstrous defect in our law that there should be a certain style or method of writing which a malicious man may use at his pleasure and to destroy his neighbor's good name without the least inconvenience to himself, end quote. But almost a century passed, and to Soane's time, by 1813, a different legal scholar could answer, quote, the common law now protects the good fame as well as the life, liberty, and property of every man. It considers reputation not only as one of our pure and absolute rights, but as an outwork that defends and renders all those rights valuable. In other words, the law of libel was changing, and Soane and others played a key role in these changes, intentionally or not. 20th of May, 1821, the first of 3 essays appeared in another journal, The Guardian, promising a blunt indictment of the then state of contemporaneous architecture. Deploring the, quote, vapid and uninteresting designs of John Soane, the author declared, quote, no exertions should be spared to check the adoption of Soane's manner. It is the most pernicious and vitiated. Nature, common sense, propriety, simplicity, all are immolated to Soane's idol, novelty, end quote. Attacked once again for the idiosyncrasy, the novelty of his architectural language, and not just in one building, the Bank of England, but now in all of his buildings to the date 1821. Soane once again quickly attempted to discover the author so he could decide whether to bring a suit for libel. 2 of close friends of Soane's recommended that he ignore the scurrilous attacks in order to avoid simply drawing further attention to the articles. One of them advised, soothingly I'm sure, that he was only paying the penalty which all public men are liable to, and which eminent and successful men in particular will always pay. The other friend worried that libel law would require Soane to prove an injury to his reputation by showing that an actual commission had been lost due to the articles. That was a burden of proof Soane could not meet. Obviously familiar with the evolving legal criteria of libel, this friend advised Soane to treat it with contempt, because if Soane were to lose in court, well, then the publicity would simply compound the original insult. Very likely, the courts by 1821 would have considered the Guardian essays to fall under the category of criticism. A familiar term to us now, criticism of literature, criticism of art or architecture. But in legal terms, this was a crucial and very new consideration, because criticism could not be cause now for a libel action, even if its form did cause some kind of damage to the reputation of the artist or architect being criticized. This new legal nuance on criticism had only just been formulated in another prominent libel case, Sir John Carr versus Hood and Sharp. This was an author's claim against booksellers who published a pamphlet satirizing his own authored works. The judge in that case stated in his charge to the jury that all artistic works, poems, books, novels, but artworks, architecture as well, all artistic works placed before the public are susceptible to fair and candid criticism. He said, fair and candid criticism which every person has a right to publish, even though the author may suffer a loss from it. The judge went on, it is a loss indeed to the author, but it is what we call in law damnum obsque injuria. It is a loss which the law does not consider to be an injury, because it is a loss which that author ought to sustain. It is the loss of fame and profit to which he was never entitled, end quote. The only restraint against such aesthetic criticism, albeit one that the judge still firmly asserted, was that the criticism could not deride the personal character of the author, except insofar as he embodied or portrayed himself in that work. In other words, the law would now distinguish between character and reputation, character being the private moral composition of the artist, and reputation being his public representation. In the case of an artist, at least, that public representation was subject now to public judgment. In a third essay on this series, chastising, disparaging Soane and his architecture, that anonymous Guardian correspondent denounced the censorship that was being implied by Soane's threats to prosecute him for libel. This is the anonymous correspondent. To those who, in the pride of their own reputation or the confidence in their wealth, unceremoniously talk of disarming criticism by legal indictment, well, we hold a very different language. That anyone who has gone onwards to wealth and honor, doubtless with large assistance from the press, should talk of prosecution when criticism dares to do what it ought to think for itself, well, whether its object be a royal academician or someone unknown to fame, to speak boldly in this way, this indeed is monstrous. No legal claim, the writer continued, could be made against honest criticism which abstains from personal insult and forgets the man while it condemns the artist. Forgets the man while it condemns the artist. This is a very careful distinction which reveals the author's new and obvious awareness of the relevant legal standard distinguishing character from reputation. Soane, instead of seeking legal remedy in the end, turned to the medium of the press himself, putting his case directly to the public. Two letters, almost certainly written with Soane's assistance or consent, soon appeared in The Sun, another journal. The first condemned the Guardian critic for his ignorance of architecture. The second reproached another newspaper for approving the Guardian essays. But grasped the larger historical significance of Soane's strategic change from legal action in the modern Goth case to public riposte here in this episode, because this reveals the moment in which aesthetic criticism is being loosened from the constraints of the law, and works of architecture are now no longer considered to be direct embodiments of the architects who created them. It was actually Soane himself who had contributed to this idea that architectural criticism had a kind of legal immunity. He contributed not only tacitly, as in the Guardian case, but because he himself had actually begun to use a very similar argument in a different situation not even 10 years earlier. The setting for this scandalous episode was the Royal Academy, that august body composed of artists, architects, painters, sculptors, of, as according to the charter, quote, fair moral character, of high reputation, end quote. Soane, appointed as the Royal Academy's professor of architecture, was obliged to deliver 6 public lectures each year to the students of the Royal Academy. These were notable events, public events, attended by students, by academicians, but also by members of London society, if they were able to secure a ticket, which was not easy. Speaking on January 8, 1810, Soane explained in his first lecture that these didactic talks would require him to discuss architectural examples. He had to therefore caution his audience that, quote, I shall be occasionally compelled to refer to the work of living architects. But I beg to assure that whatever observations I may consider necessary to make They will arise only out of absolute necessity, and not from any disposition or intention on my part to point out what I think may be defects in their composition," end quote. Soane, so keenly sensitive himself to the barbs of criticism, was evidently alert to the need for propriety in the setting of the Royal Academy, whose members were, by definition, in its charter, considered to be distinguished, accomplished artists who merited their own high reputations. On the evening of January 29th, 1810, Soane delivered his fourth lecture. He employed in these lectures large drawings specifically commissioned by him to illustrate his points, proceeding in the lecture to a discussion about buildings that failed to resolve into one unified form. And as an example of the undesirable practice seen, he said, in many buildings of the metropolis, of embellishing only one facade at the expense of all the others, he placed before his audience these two illustrations of the side and rear facades of the recently completed Covent Garden Theatre by the young architect Robert Smirke. Quote, "These two drawings of a more recent work point out the glaring impropriety of this defect in a manner, if possible, still more forcible and more subversive of true taste, the public attention from the largeness of the building being particularly called to the contemplation of this national edifice," end quote. It may seem subtle to us now, but Soane's derogation of this architecture, the architecture of a fellow Royal Academy member, shocked his audience, many of whom immediately began hissing loudly in protest, standing up, walking out of the lecture room. Soane had obviously anticipated the offensive effect of his remarks, for he immediately added, "It is extremely painful to me to be obliged to refer to modern works. But if improper models, which become more dangerous from being constantly before us, are suffered from fault delicacy to pass unnoticed, they become familiar. And then the task I have undertaken as professor would be neglected. Not only neglected, but the duty of the professor becomes a dead letter," end quote. He then disingenuously proceeded to recite verbatim the laws of the institution of the Royal Academy that forced him to offer such criticisms so as to edify his students. He only intended his two illustrations to show the contrast between the front facade and the wholly plain, unadorned sides and rear, whose plainness suggested a warehouse rather than a civic building. Soane's public criticism, though, which was, in fact, in truth, motivated as much by Soane's spite towards Robert Smirke as by any pedagogical intention, Soane's public criticism provoked the Royal Academy to a quick response. Within a week, the Council of the Academy had ratified a startling resolution that now prohibited, quote, "any comments or criticisms on the opinions or productions of living artists in this country," period. Soane replied in turn. He would then refuse to resume his lectures, his duty as professors, as long as this censorious resolution remained in effect. The resolution was so broad that it prohibited even comments on any aspect of a Royal Academician's work. This was a reaction not just against Soane, but against severe partisan criticism that increasingly circulated in newspapers and reviews outside the Academy. Each year, the Royal Academy annual exhibition exposed individual painters and sculptors and the Royal Academy itself to the public judgments of the press, and those judgments were scathing more often than not. In this period before illustrated newspapers and journals proliferated, criticism often circulated much more widely than the paintings or the sculptures that it addressed. Even architecture, more visible in the daily course of life in London, was depicted textually to a large audience who remained unacquainted with the actual works. So the Royal Academicians' negative experience of the exhibition reviews of their own work undoubtedly swayed them, many of them, to vote in favor of this ban, which promised to maintain the Royal Academy as a kind of sanctuary in which one's high reputation would never be impugned. But while a large group of academicians had reacted adversely to Soane's comments about Smirke, others agreed with him that the instruction of students required such criticisms, and they expressed their support to him, but they expressed it privately. Public support for Soane's position did appear in letters to the editor, which objected to the quote-unquote disgraceful resolution. Others declared, quote, criticism upon the arts is necessary to their preservation and their improvement, as the liberty of the press is necessary to preserve freedom and the moral state of society, end quote. This rhetorical figure, criticism is the improvement of society through disciplining of public taste. This, as I explained a moment ago, this was the same as the basis for the legal defenses against libel, including, of course, that Modern Goth episode, in which the defendant's counsel had rebutted Soane's charge by saying that criticism, quote, keeps dullness in the background instead of letting dullness stalk forth in the glare of public life, end quote. The Royal Academy scandal formally ended in 1813, probably through the mutual exhaustion of the two antagonists. The General Assembly passed a statement saying that regretting that Soane had taken personal offense at a law that they intended to apply not to him, but generally. An appeased Soane then recommenced his lectures. But the question of criticism wasn't really settled within the Academy. Soane ended the final lecture in his series by quoting the closing lines of Alexander Pope's famous 1711 essay on criticism, claiming for himself, rather implausibly, Pope's attitude of a selfless, disinterested critic, pursuing only the truthful knowledge and love of architecture. By Soane's time, though, criticism, invariably accompanied by some disapproval, had already become a staple of public discourse, transacted in the competitive press of London. Soane perceived the timely role for criticism to be prompted by the very fact of architecture's public role in civic life. The special urgency, he said, of his criticism of the Covent Garden Theater, which he clearly endeavored to show in as unflattering a light as possible. That attention, that urgency was due to, he said, the public attention being particularly called to the contemplation of a civic building. The visibility, the presence of architecture, of the public eyesores in the metropolis was being calibrated now by these emerging conventions of criticism, but also by those emerging mechanisms of libel law. The most notable judgments may have predictably pertained to buildings of national significance, the Bank of England, the Covent Garden Theater, but these were not exceptions at all. Rather, they were part of a broader and continuous public assessment in the press of the physical monuments of civic life. As one side example, when Soane and Smirke and their contemporary John Nash were all three appointed together architects to the Board of Works to advise the church commissioners of London in the building of many hundreds of churches in the metropolis, they were trying or joining in an effort to construct many churches for minimum expense. One of Nash's designs, All Souls, that you see here, received particularly scathing derision in the House of Commons when a member of Parliament, Henry Grey Brennett, rose up from his seat to say, quote, "It is a deplorable, a horrible object. Never had he seen so shameful a disgrace to the metropolis. It was like a flat candlestick with an extinguisher on it. No man who knew what architecture was would have put up the edifice," which disgusted everybody and made everybody wonder who could be the asses that had planned and the fools that had built them. Parliamentary privilege, as exists in the United States, protected Bennett from any potential legal repercussion. Statements made in the House of Commons were and are exempted from prosecution for slander. More curious, maybe more perceptive, certainly more witty, was this caricature that the incident inspired. Titled with a pun, "National Taste," the drawing shows architect Nash balanced uncomfortably, shall we say, upon the spire of All Souls, posterior impaled upon its tip, and carrion birds above. The Guardian essays, those essays that criticize Soane's pernicious aesthetic influence, those essays were published after his dispute with the Royal Academy and the censoring of his own critical views. It is clear that Soane developed a fine sense of the evolving legal standards that surrounded the matter of aesthetic criticism. Amongst the clippings in Soane's scrapbooks can be found dozens of reports of sundry types of libel trials. Some of these are defenses of professional competence of different architects. Some of them are defenses of women's honor. They all suggest a very intense interest in libel law on Soane's part. But though through this interest Soane may have developed a finer sense of libel law, he had certainly not developed any thicker skin. In June 1827, the Court of King's Bench convened to hear yet another case, Soane versus Knight. Soane, apparently against the express advice of his legal counsel, had brought another charge against the publisher of Knight's, another libel charge against the publisher of Knight's Quarterly Review, for printing a very long satire of Soane titled The Sixth or Boeotian Order of Architecture. Like the modern Goth, this new satire mocked the novelty of Soane's style, the idiosyncratic aspects of Soane's architectural work, and sarcastically characterizing them as a Boeotian order, a reference to the classical characterization of the inhabitants of Boeotia as dull and foolish people in comparison or inferior to their Athenian counterparts. Characterizing them as Boeotian, the satire of Soane's architecture deplored, for example, the disproportion of columns and pilasters in Soane's work, the discordance of the parts to the whole in Soane's work, and in particular, the hanging arches, quote, miraculously suspended by the back, like the stuffed crocodile on the ceiling of a museum, end quote. Following arguments here in the Court of King's Bench, and of course, following yet again a humiliating public recitation of the entire offending essay, the jury immediately found the defendant not guilty of libel. Given the legal standards I've outlined in these previous episodes, the verdict could not really have come as a surprise. Soane's counsel did attempt to portray the public ridicule of this particular satire as evidence that the critic held, quote, private pique and private malice against Soane, end quote. But the defense responded by citing all of these new legal precedents on the permissibility and, most of all, the importance of aesthetic criticism, emphasizing the idea that such criticism improved society by elevating works worthy of acclaim and by exposing works deserving of ridicule. It was, argued the defense counsel, quote, it was the undoubted right of the press to endeavor to correct the public taste and to explode by argument or by ridicule all false notions and erroneous works. This regulatory function was all the more vital, he said, in the case of architecture. Only a building, quote, that can stand the butt of ridicule becomes immortal. For that which ridicule can put down ought to be put down. If this remark applies to books, he said, still more does it apply to the architect whose works, like his materials, are lasting and who is covering a metropolis with them, end quote. Covering a metropolis with them, while adding to the obvious injury inflicted on Soane by the trial and the loss, the reading into evidence of the entire text, the consequent repetition of the text and the whole episode in newspaper accounts, and of course the failure to win, adding to all these injuries was the fact that the proceedings were held in a building of his own design, the new law courts at Westminster Hall. During the construction, Soane had already endured the inquisition of his design by a parliamentary committee convened to question his decision to, curious in their eyes, decision to append a neoclassical front to the existing Gothic fabric. This is the first design here. He was ordered, in fact, to demolish this part of the work and to provide a more congruous addition, more in keeping with the Gothic fabric. Well, now, during the 1827 trial, held in the Court of King's Bench inside of Soane's building, Soane had to listen to the defense counsel's own superfluous addition of his own opinions on the design of Soane's law courts. Quote, with all respect to Mr. Soane, I do confess that I really think he has made a mistake in these courts of justice. I assure you, I was nearly killed in the passage getting into this court. So ill-contrived, as I think, are the passages, end quote. This caustic remark unambiguously reveals to us how critical public opinions had now been sanctioned by the evolution of libel law. Of course, architecture had previously been subject to scrutiny and to opinion. But now the contours of that scrutiny have been more specifically defined in a manner that substantively deflated any possible mechanism of censorship. By sanctioning the critique of architecture, as long as it did not disparage the person of the architect, libel law had forged the principle of a subtle but crucial separation of architect from his architecture. With this separation, the embodied imagination of architecture could be segregated from the moral standing of the architect. The relationship of those two might still be examined, but only now by fair, manly, and candid criticisms. To conclude, I want to return us to 13 Lincoln's Inn Fields, that palpable eyesore with which I began, and to take a note of the final step in Soane's careful negotiation of his private imagination and his public reputation. The house, as you know, is now the Soane Museum. That remarkable projection of Soane into a lasting and now perhaps perpetual publicity occurred on April 1st, 1833, when the House of Commons approved a private act of Parliament bequeathing Sir John Soane's house to the public as a museum after Soane's death. This hearing and this law, this bill, was also attended by controversy, by some scandal, and certainly by some malice. When motioning for the second reading of Soane's museum bill in the House, Joseph Hume, the Member of Parliament, presented to his colleagues in the House of Commons, quote, "The case of a gentleman of a distinguished reputation and attainment, who having derived everything he possesses and all the property he enjoys from science," meaning architecture and the practice of the science of architecture, having derived everything he possesses from science, has bequeathed in this noble and disinterested manner the result of his labors, purely with a view to promote the cause of that to which he owes his own celebrity, science, end quote. But prior to the final reading of the bill, and therefore the vote to pass the bill, the members of the House of Commons debated for the better part of an hour not only the legality, but the morality of Soane's donation. They raised implicit and explicit questions about Soane's private character and his public reputation. George Soane, Soane's estranged son, had submitted to Parliament a petition against the bill on the grounds that the donation of Soane's house would alienate an inheritance that was rightfully due to him and his children. William Cobbett, Member of Parliament, presented George's petition to the House, arguing that he, Cobbett, could not, quote, "countenance a grandfather diverting the means of sustenance from his nearest relations," end quote. Cobbett even questioned whether Soane had the right to donate his house and its contents, noting that much of Soane's personal fortune derived from his wife's inheritance. He asked, quote, "Now, sir, who is to say how much of that celebrity and renown which Sir John Soane has attained may have been created by his wife's money," end quote. This aspersion upon Soane's reputation provoked Hume and other MPs to protest and denounce interference with Soane's legal right to dispose of his property as he pleases. Such insults, they declared, were as incredible as the imputation that Sir John Soane, quote, "meant to let his grandchildren starve," end quote. In a compromise, the supporters of the bill accepted an amendment allowing Soane to choose, allowing for the bill to choose to donate the collection to the house to the British Museum in order to enlarge the inheritance of Soane's heirs by releasing funds otherwise dedicated to preserving the house. And with Soane's reputation defended, the House of Commons passed the Soane Museum Bill. Not only did this debate in the House of Commons draw upon Soane's personal affairs to gauge his public reputation, but the legal consequence of the act was that Soane's house, his embodiment, his personification, became the property of the public. The only qualification in the gift was an absolutely crucial one, that the house and its contents be preserved in their arrangement and condition upon Soane's death, to ensure that Soane's construction of his own publicity would remain intact. Shortly after Soane's death in 1837, the Penny magazine published a descriptive essay on the house and museum of Sir John Soane that emphasized the peculiar union of house and museum, but withheld judgment. And, quote, it said, and quote, "What, it may be asked, is the practical use of Sir John Soane's house and museum? Well, it does not come within our province to criticize," end quote. Well, we know that Soane did not disappear from public view, and he's not been left out of the light of publicity. Some of his friends and acquaintances, and later some of the conservators of the Soane Museum, became guardians of his reputation. Others became or continued to be his critics. I'll leave you then with a thought expressed in 1949 by the then newly installed director of the Soane Museum, Sir John Soane. Quote, "When Sir John Soane obtained in 1833 a private act of Parliament for the preservation in perpetuity of his house and museum, I wonder what sort of perpetuity he imagined. Was he thinking of 100 or 1,000 or 100,000 years? 100 would show him to be a prudent man, 1,000 a vain man, any longer term, a megalomaniac." Thank you.
Thank you, Timothy. That was really wonderful. Do we have some questions in the audience?
At what point during his career, Soane, the neophyte architect, Soane, the pinnacle architect, or post on his way out, did these lawsuits and his obsession occur with him?
All three. So I mean, the first case is 1799. So it's still in the early stages, the first phase of the Bank of England project. So it is quite early on. A little past neophyte, he is already a celebrity, right? He is building large civic works. The obsession with his own celebrity, fame, public persona is evidently there quite early on, though. As I'm sure many of you know, Soane's family name was Soane. He added the E himself to make his name more distinguished, which he did when he arrived and began working as apprentice in London. And the cases continued all through all of those stages of his career.
Did King Charles' criticisms of architecture as Prince of Wales inspire any similar litigation?
They did not inspire direct litigation, in part because of his particular legal standing. The legal implications that came into view because of his criticisms of architecture were around the status, which is a legal status of then Prince Charles as the monarch in training. The monarch in training is a particular constitutional categorization in the English Constitution, which specifies that the heir to the throne will enact or will essentially follow the monarch in order to learn the trade of being monarch, and that this allows for their participation in certain kinds of activities. However, they are not the monarch, so it also disallows other activities, which included, in the case of his public pronouncements on architecture, potentially his public pronouncements that applied to cases of architecture that were in the course of getting planning permission, because that is particular legal status for architectural projects in England. So for the king, for the monarch in training to be making statements that could be influencing a planning permissions process is unconstitutional, because the monarch is not allowed to actually intervene in a legal proceeding, such as a planning process. So in making those comments, what Prince Charles' advisors declared was that he was making them as a private citizen. His antagonists made the argument that he was making them as monarch in training, king in training, and therefore that they were unconstitutional. There is actually, though, no court proceeding to resolve that particular constitutional conundrum.
Just one more question.
Did the aesthetics change between 1812 on the house and the time that it was received in 1833 in the House of Commons? The discussion seems to have changed to more or less what would children inherit. So I was wondering how the aesthetic criteria had changed.
Well, by the time of the hearing of the bill, the interior of Soane's house had already become quite public. You know, I think as many of you know, he was already holding evenings, open evenings to the public. Also very hard to get a ticket for those at the time, where Coleridge and others, you know, came and commented, as well as the press. So I think by that time, the house was seen in a different light aesthetically, yes, but probably because it had become an object, in a sense, of public familiarity, that there was a sense of already a kind of public entitlement to that space. And I mean that it would no longer be seen as Soane intruding himself on the public, which was the case of the facade and the complaint lodged against the facade. Now the whole interior was part of the public realm, even before the hearing of the bill. And so there wouldn't be that same sense of Soane forcing himself, as it were, upon the public.
Thank you very much, Timothy.
Thank you very much.
Please keep your eyes open for March 24th. Announcements will be coming, and we look forward to seeing you then. And please join us next door for cocktails afterwards.